Thank you very much, and you're welcome back. First of all, apologies for the initial hitches that you suffered. I understand that some of you did not even hear the introduction that I gave. I'll repeat that by just going back to it, and this is what I read. Quote, "In our view, following the previous decision of this court in the Abu Ramadan case, by which the use of the cards for registration was declared unconstitutional, the continued presence of names on the register that derive their identification from the said cards renders the registration the register not reasonably accurate or credible," unquote. And that is coming from the judgment. But did the Supreme Court order the EC to delete names of those who used NHI cards to register for the 2012 elections? That's the question. We'll deal with those. We will deal with matters arising from the ongoing registration, the infamous Baumia comments, and if we have time, deal with ROPA. Welcome once again. This is Newsfile. It's your most authoritative news analysis show, brought to you by the kindest sponsorship of Bank of Africa, strong as a group and close as a partner. MTN, welcome to the new world. Star Assurance, creating smiles since 1985, celebrating 30 years of solid partnership. NIIT, bringing people and computers together successfully. Now, I've got two of my guests in the studio. We'll start with them as we wait for the others, particularly with some preliminary issues that we need to touch on. But before we do, as always, let me quickly do my take today. And my take today, just by way, is to join the Supreme Court in congratulating a very good friend of mine, one time a roommate of sorts, Martin Pebu, for the journey he embarked on in the Supreme Court in February of last year and the judgment that has come. As a rights activist, I am very excited about it, but there are challenges that we need to point to and urge the state to ensure that these challenges are resolved. He was in the Supreme Court and asked that Section 96, subsection 7 of the Criminal Offences Procedure Act and Juvenile Procedure Act be struck down as unconstitutional. And this is the provision. The provision says that a court shall refuse to grant bail in a case of treason, subversion, murder, robbery, hijacking, piracy, rape, and defilement or escape from lawful custody, or acts of terrorism, and B, where a person is being held for extradition to a foreign country. In fact, there was an amendment to that which also included non-bailable offense being narcotics. So what it meant is that since 1960, if you were accused and charged with not having been tried and convicted and charged with treason, subversion, murder, robbery, hijacking, piracy, rape, defilement, or that you had escaped from lawful custody, or you are engaged in acts of terrorism, or you were for purposes of extradition to a foreign country, or you had engaged in narcotics, you were not entitled to bail. The Supreme Court heard him and came to the conclusion that, yes, they agree with him, it is unlawful, and they have consequently struck that law down because it is against the very grain of the Constitution. Article 19, for example, is to the effect that all persons who are suspected or accused will be presumed innocent until they themselves plead guilty or they have been proven guilty by the courts. But you know in this country that suspect have continued to suffer because of the failure of the state to speed up trial. Some say the law also provides that if you are found not guilty in the end, you could be compensated. And I say, wasted precious years cannot be compensated in cash. What the non-bailable offenses categorization did was that it was subject to abuse by, for example, bitter sexual partners or ex. What they simply had to do was to make a claim of rape, an allegation of rape at a police station, or defilement, or if you had a friend or a business associate who had issues with you, all they needed to do was to set you up with some narcotics or other felonies or high crime allegations, and you will not be granted bail. There are people who have spent upwards of 12 years, 15 years behind bars on remand. How is that justifiable? So this is very good, but I say we need to watch three things, and I'll deal with them briefly. We have a poor and non-existing address system in this country. The same Martin Pebu was in that court and secured a judgment that said that sureties cannot be held for the disappearance of the suspect of the accused. You cannot be imprisoned because the person you stood surety for has escaped. Now, what that means is that I find that there may be a temptation to escape the jurisdiction if a person knows that they are guilty and that they may suffer death, they may suffer life imprisonment, 50 years, 27 years, so on and so forth. How are we going to make sure that these people, accused persons, will not escape the jurisdiction? 2, doesn't this have the potential to increase the temptation for such persons who are accused or charged to want to seek to compromise and corrupt, especially lower court members of the judiciary, since now the decision is left absolutely to their discretion? Of course, the discretion must be exercised judicially. But if people involved in narcotics are brought, you know to what extent, length they can go. How much money will they not pull up that may become so difficult for somebody to refuse and to grant bail and say, after all, I'm just granting bail. It's not as if I am acquitting the person. And finally, this certainly will add to decongest the prisons, like the court said, but is the state ready to pay for the reforms that are required to produce, the facilities for reasonably speedy trials? I suspect that I can't see any change or so much change in the next decade. Thank you very much. That's by way of my take. And I say I joined the Supreme Court in congratulating Martin Pebu. Thank you. And of course, one of my guests has also joined us, so now we are 3. Let's begin the game now. We have in the studio presently, maybe I'll do what I did the last time and Kuku said that was diabolic. I'll do by order of who was in the studio first. Dr. Puku Edusei is senior lecturer, University of Ghana School of Law, and member of the NPP. Good morning and welcome to the show.
Good morning, sir.
Well, he taught me methods of research in my LLM. Thank you very much. Also in the studio is Yao Opong. He's legal practitioner and lecturer of the Central University. It's no more a college, it's a full-fledged university.
That's right.
He wants me to give that emphasis. Right, thank you very much and welcome to the show.
Thank you, we have earned it.
Right. And also in the studio is Abdul Malik Kweku Bako, editor-in-chief of the New Crusading Guide newspaper. He's a regular panelist. And on an occasion like this, I always say he's my finest street pocket lawyer. You'll hear his views on the judgment. And we'll be joined later he's not yet in the studio, by Alhaji Inusa Fuseni, who is Minister for Roads and Highways and MP for Tamale Central. He's also a lawyer. Alhaji, hurry this way so that we can have a complete set for the discussion. Thank you very much. Now, by way of preliminary comments, and I had a feeling really that today we may even have to skip that because it may not be important, but we need to deal with it briefly. First of all, and we're dealing with it within minutes and 2 minutes each of your submissions. You are not supposed to do more than that. First of all, we know that the Nana Akunedo Ajman Rawlings has been endorsed to be the flag bearer of the NDP. There's comments already by people in government or in the NDC that she will not amount to much. She's insignificant to the whole political arrangement as far as 2016 elections are concerned. What do you say, Yao?
Well, thank you very much, and good morning. Well, I think that the growing evidence is that when persons who have been members of a political party, well, those that may be referred to as major political parties, the NPP and the NDC,
right, when
they have quote-unquote defected and formed their own political party, they have not done very well in subsequent elections in which they also, or they and members of their party who were nominated as parliamentary candidates really did not do very well. They have not done very well. I mean, if you take even Mr. Indum's, is it PPP?
PPP, yeah.
Even though if the MPP and the NDC aside, they have been the third, I think in the 2 previous elections when the political party was formed. They were usually around less than 3% or thereabout. So it may not be so significant in terms of, I mean, the PP, the Nana Akunedo's party, or herself as the candidate. But I think that what should not be discounted is the fact that the wife of the founder, even though the Constitution says there's nobody called a founder of a political party, in a way that party has admitted that they will prefer to refer to him as a founder.
Right.
And he has held himself out as the founder of that party.
Right.
For the wife of a founder or somebody who has played a major role in the formation of a political party to now, as we succeed, to form her own political party. And sometimes you see Mr. Rawlings actually endorsing by his presence.
Particularly this last time.
Yes, by his presence, endorsing the decision by the wife, together with a couple of the children, where one lady is still with NDC, one, we don't know whether...
Senator Rawlings is contesting.
Yes, but the gentleman, the young man, we don't know whether he endorses the mother's party or the other one.
But they were present to give her their support.
I don't think I saw him, but yes,
okay, yeah.
but maybe he is indifferent.
Right.
And he wants to look at the policies of the two parties and maybe vote according to his conscience and not in terms of familial relationship. So that is what I think may be significant.
Right.
But otherwise, as for winning vote, I cannot foresee that in the immediate, to even the future
Thank you very much. Alhaji Inusa Fuseni has just joined us. Thank you very much for joining us. Good morning.
Good morning.
Great to have you.
Thank
now,
you.
Now, Dr. Disse, what do you say? The former president was present, not just being present this time, but this time round, he gave his full support to the wife and actually called the people in the NDC names, called them thieves.
Well, thank you. I think objectively it is significant that Mrs. Rawlings has not only seceded from the NDC, but she is now forging ahead to, as it were, become the president of the Republic of Ghana. And from the endorsement from President Rawlings, it tells you that that's where his heart is. And for that reason, it's very important for us to see it as not just any ordinary succession, and that is coming from the founder and the family.
Some say the former president doesn't command any weight any longer in the NDC.
He does. He does. He's respected across the political divide. I mean, in Ghana, if you talk of the grassroots and what Rawlings can do, think of 2008 elections and how he was even able to commandeer places like Tyne for elections to be concluded in 2008. He's very popular on the ground.
You're saying that you suspect he can influence votes for the wife to affect the NDC negatively in 2016, in November?
I think so. And the woman is herself is very charismatic. But for her disqualification in 2012, she would have performed creditably well, and that could have gone to reduce the votes of the NDC in the elections.
Interesting. Honorable Yunus of Seni, some look at it in these lenses. They say, well, Guzitando tried. Well, didn't really make any impact, so to speak. So, what's the big deal?
But many after Guzitando have
right. I've not made it.
NDC, someone.
Yes, yeah. NDC is a colossus. Even Mrs. Rawlings, in her first attempt, was not going to make any showing at all. I mean, the disqualification to the NDC was seen as a respite for her because we thought that she was going to perform abysmally in the elections. And so we watching the situation. Flight Lieutenant Rawlings still remains the founder of the NDC. He's going to endorse another candidate. We're watching because our constitution has clear provisions on the conduct of persons which seems to touch and concern activities within the party. And so we're observing, and in due course, I think the party will respond appropriately.
Interesting. Kwaku?
Yeah. Well, I might be wrong. Maybe my memory is not helping me at this stage. But the only breakaway from a mainstream party or movement that has had an earth-shaking effect in our history was the CPP from the UGCC. That is what had an earth-shaking effect. I've looked through the landscape, the historical, or if you like, the political landscape. I'm yet to see any other breakaway that had the same effect the CPP's move from UGCC had. That's why I said perhaps I'm wrong. Okay. Maybe somebody can give us a classic example that may be close, if not equal, to the Nkrumah one.
The UNC.
The UNC was not exactly a breakaway. I keep on saying this thing. There were few elements from the PP tradition or the UP tradition who were in the UNC. There were many others who were not there.
Right.
The Nile people and all those were not part of the UP tradition. At least check the Second Republican framework.
Right.
And then you see that those people were not part of the UP tradition, at least relative to the PP time in office.
Right.
So we should be clear. There'll be many breakaways. I'm not saying of not some significance, but I'm talking of the impact. Otherwise, of course, even Joe Appiah's breakaway from the UP tradition to form the Ababase was significant. There have been many significant, but someone's exit from was significant. I'm not talking of just the significant. I'm looking at the impact it had on the mother tradition or the mother party. And I'm saying that apart from the CPP one, I'm yet to see any one that had that same earth-shaking effect. Now, that apart, is the post-2000 elections, when the NDC went into opposition, it began to organize itself into a political party in the true sense of the word. Unlike what Vincent Assisi had described as an electionary machinery for those periods. And they undertook a certain reorganization project, if you recall. Gradually, that was during the period that Mr. Rawlings ceased being both founder and leader at the same time in terms of their constitutional arrangements. They became just the founder. The more the party grew, or the NDC grew into a political party, the more the Rawlings influence was decimated progressively. It's a fact. And then all the crises he had with Professor Mills overrunning maize and so many other matters. I'll tell you something, Rawlings' name remains in their constitution as the founder. The June 4th and 31st December dates are captured as the anniversary days of glory. But effectively, politically, Mr. Rawlings' influence has diminished in the NDC of today. The NDC chaps themselves will not want to admit that for sentimental and nostalgic reasons. But that's the reality. Now, Mrs. Rawlings, it's true she didn't compete the other time, so it's difficult to do a statistical, assessment of.
Right. If you can wrap up in
I'm
30
about to
seconds,
finish.
yeah.
It's an important question you asked.
Right.
I didn't know you're going to make it part of this subject,
Okay.
but since you brought it, give me space, and I'm not asking for too much time anyway.
All right, go ahead.
The point really is that she didn't compete the other time,
Right.
so we are unable to do a statistical assessment
Okay.
of whatever impact. She would compete this time from the way things are going.
Right.
We still will have to wait to see the outcome. But I can tell you one thing that will be clear is that the nuisance value in terms of the propaganda, that one, yes, they can cause some irritation and headache to the NDC if especially the husband decides to join her campaign trail. I think it's too late in the day for Rawlings and Mrs. Rawlings to go out there and decisively affect NDC performance or in terms of votes.
That may be a note on which we can end it here. Now let's listen to former President Rawlings and what he had to say on that platform. All right, we seem to have some difficulties. We are unable to play that sound immediately. When it's available and we're able to play it, we'll bring it to you. But now let's move on to the Supreme Court and try to understand the judgments that was given in respect of the case of Abu Ramadan Evans Nemakon versus the Electoral Commission and the Attorney General. Now, the biggest bone of contention so far, I think, will be suggestions that the media got it wrong in reporting that the court had ordered deletion of decents, as deceased people, minors, and people who use NHI cards. That is the bone of contention now. It appears all the parties involved agree that the court says they should remove dead persons and minors. But the question is now on whether the court said those who hold NHI cards, use that to register earlier, should also be removed. Did the media get it wrong? Now let's find out and see if the media didn't get it wrong, how is the EC going to be able to undertake that job handed it by the court between now and the elections? Once again, I want to start with Yao.
Yes, thank you very much. I think to be able to answer the question, I would like to look at the reliefs that were filed or brought before the court,
Right.
by which they asked the court to grant or make declarations of. And the one that relates to this specific issue is Relief 2, which says a declaration that the current voters register, which contains the names of persons who have not established qualification to be registered, is not reasonably accurate or credible, and therefore inconsistent with Article 45A of the Constitution, thereby making same unconstitutional, null, void, and of no effect. And as we know, when reliefs are brought before courts and they are opposed or become a dispute, issues are raised on them. Now the issues, what is called at the Supreme Court, memorandum of issues that were agreed between the parties. You find the one that relates to this under issue 2, which was whether or not the presence of names of ineligible persons on the current register of voters renders same not reasonably accurate or credible, and therefore inconsistent with Article 45A of the Constitution. So in addition to the resolution of the other issues, the court now then set out to resolve that issue. And it starts from page 19. We next proceed to consider issues 2 and 3. The court actually fused the 2 issues and resolved them. So issue 3, which also relates to relief 3, is a declaration that the current voters register, which contains the names of persons who are deceased, is not reasonably accurate or credible, and is therefore inconsistent with Article 45A of the Constitution, thereby making same unconstitutional, null, void, and of no effect. The court decided to resolve issue 3 first, even though it had consolidated the 2.
Yeah.
But it clearly set out to delineated the 2 and then set out. And this is what it said, that the said issues concern the question whether by the continued presence on the current register of voters of ineligible persons as declared in the Abu Ramadan case and the deceased persons, the register can be said to be reasonably accurate, said not to be reasonably accurate or credible, and therefore inconsistent with Article 45A of the 1992 Constitution. The court accepted the fact, and there's some profound declaration here, that in our opinion, death being an inevitable occurrence in life of any human being should have had very clear provisions made in relation thereto for the purpose of deleting such names, and went ahead to actually declare that the presence of the names of deceased persons renders the voters register not reasonably accurate or credible, and therefore also wondered why the birth and death registry have not been involved in the deleting of these names. And it's a point that I think we can also make, because I don't see why we should always wait till some few months before election before we start talking about deleting the names of deceased persons from the register, because it's something that, as the court affirmed, occurs in our life. Now then, turning to the presence on the register of voters of ineligible persons who must have...
Kindly hold on briefly. Yes. I think for the purpose of this judgment's interpretation that has become so critical, let me just do a reading of this portion.
Right.
Then you go to the next portion.
Okay.
So this is what I just want to read from a certain point that will help all of us to understand.
Definitely. Yeah.
Now, it says that, in our opinion, death being, I think, you'll be looking at 19 in yours. Mine, I'm looking at 20.
No, it's actually 20.
Right. 20, correct,
Yes,
you're
okay,
right.
okay.
It says that, death, in our opinion, death being an inevitable occurrence in the life of any human being, I think should have had very clear provisions made in relation thereto for the purposes of deleting such names from the register by, for example, requiring the births and death registry to forward at specified intervals to the first defendant, that is the Electoral Commission, through its district offices for deletion. The unhappy situation, however, is that the system of registration of births and deaths in this country is woefully behind current trends in development. This has the effect of rendering the current register of voters not reasonably accurate or credible. We do not, however, think that the defect is so extensive in nature to result in an inconsistency with Article 45 1A of the Constitution, as the existing law has made ample provisions for such names to be deleted when the provisional register is exhibited before it is certified under Regulation 27 of CI 91 as the existing register. We think that the elaborate scheme provided the law is sufficient. I think they wanted to say provided under the law is sufficient to address the presence on the register of voters of names of persons who might have died since the last registration exercise. Although the issues for our determination have not included minors, we think that names of such persons can also be deleted using the processes provided for in the law. From the complaints made in relation to deceased persons, there is an implied admission that at the time of their registration, they were alive and eligible to be registered. There is also the added mechanism of biometric registration, which when enforced will prevent people impersonating such deceased persons, as the fingerprints and photo identification will not match. So like you said, the two issues of minors and dead persons has been catered for. They say this is how to remove them. Use the exhibition process to remove them. Move to the next issue that you are looking at, which is the NHI card holders.
Yes, so with the NHI card holders at page 21, now the court said that turning to the presence on the register of voters of ineligible persons who must have utilized cards for their registration, it appears from the proceedings therein that the exact numbers are unknown.
Right.
Now, this creates some difficulty, but for me, the most important aspect of this is also at page 21. In our view, which is what you read at the beginning, following the previous decision of this court in the Abu Ramadan case supra, by which the use of the cards for registration was declared unconstitutional, the continued presence of names on the register that derive their identification from the said cards renders the register not reasonably accurate or credible. So that is, for me, very significant. They also supported this view by reference to the report of the committee that was established by the Electoral Commission,
right,
which was in there as Exhibit ABU 6, in which the court said that the register of voters, quoting them, that the register of voters is bloated, a fact which is not controverted by the defendants. But surprisingly, the court, with all due respect, well, then went ahead to say that that body only play an advisory role. And I have made the point before that I support those who say that whole arrangement, that's a bit of digression, was a bit bizarre to me. Because here is the commission that has set up a committee to look into some matters. As part of the terms, it stated that they only played an advisory role, and that the commission reserved the right to accept or reject the recommendations or words to that effect. Then the commission also appears before that same committee, articulates clearly their own position on these matters that have been referred, and then turn around to say that whatever they say was also subject to acceptance or rejection by them, and which I think, well, it wasn't quite proper in my view. So the court clearly stated that those names which found themselves in the register, for example, before the 2012 election, could or have made the register not credible and accurate.
NHIS card names.
The NHIS in particular, even though they didn't use the word NHIS, they said those cards.
Yes, but they had already defined it earlier.
In the Abu Ramadan case.
No. Even in this case, they had defined that from that point on, they were not going to be saying NHIS cards. They will simply say cards, and it will mean NHIS cards.
Yes, okay, right, thanks. So, at this point, then there was a definite pronouncement on that.
Okay.
But it is the subsequent pronouncement on this particular issue that I think have made some people then render one understanding or the other.
Right.
Because when you look at page 22, that in view of the fact that these registrations, that's the cards, were not effected in breach of the law, the persons affected thereby cannot be said to be benefiting from their own wrong, such as to be deprived of their registration without being given the opportunity of being heard. And I hold the position as well, that in all cases, especially if you remember the WAEC case, once a person is going to suffer a liability, not only must he be given a hearing, but a fair opportunity to be heard.
You're talking about Awuni and WAEC.
Yes, okay. Awuni and WAEC. Fair opportunity to be heard. And in this case, for example, where a person is in, let's say, Brim North constituency, and in Brim North there are some villages by which somebody will have to travel for many hours or even walk for about many miles before they get to the district. How can you say that even in that case they've been given fair opportunity to be heard? So then the court went on.
And that reminds me, in the Abu Ramadan case of 2014, which judgment was delivered on 30th of July, I was in court when they had to make the Chief Justice, who was presiding, ask questions about what they wanted to do when the cards have been declared unconstitutional.
That's right.
And they suggested that it should affect whatever has been done with those voters.
Yeah.
The court told them that they could not make a decision that affects those people without those people being given the opportunity to be heard.
Yes.
So proceed.
But that is not consistent with what others are saying, that a deletion of it will amount to a retrospective application of the law to the extent that it will be contrary to Article 107. All right. I held the view that as far as possible, that decision would not affect what they use the cards to do, the registration card to do, i.e. voting in the 2012 election. But it does not mean that the continuous presence of their names in the register is it makes it credible. So what it means is that they cannot be allowed to use that card they obtained on the basis of the NHIS card to vote again. And that will not amount to retrospective application of the law.
Okay.
In my view, that will rather enhance the decision of the court. So then the court went ahead to say that it adopted an approach that in its view referred to as doing justice in a manner that preserves the rule of law and a stable constitutional order without affecting acts and all things which were previously ordered. And then said, we think that any person whose registration is affected by the decision in the Abu Ramadan case be given the opportunity to go through the process of registration. But even more significantly, to establish his eligibility. So it doesn't mean that the fact that your name had previously been on it, when you're going through the process of registration, it becomes automatic. Because we were not sure that all those who use the NHI cards were eligible Ghanaians. The court is saying that there is no automatic re-registration of such people based on these other cards. Then a question may be asked, if I guaranteed for a person who didn't have any card, but I obtained my registration based on an NHIS card, that person I have guaranteed for, what becomes of his own registration?
Okay. Now, what my listener wants you to do, and I want you to do that quickly so that we can move on, is this. What is the effect of what the court said? In 32, it says that the result is that we proceed to grant the following reliefs.
That's right.
1. That upon a true and proper interpretation of Article 45A of the Constitution, the mandate of the Electoral Commission to compile the register of voters implies a duty to compile a reasonably accurate and credible register. 2. A declaration that the current register of voters, which contains the names of persons who have not established qualification to be registered, is not reasonably accurate or credible.
Yes.
3. A declaration that the current register of voters, which contains the names of persons who are deceased, is not reasonably accurate or credible. 4. Reliefs 4, A and B are dismissed in their entirety. In the exercise of the power conferred on us under Article 2.2 of the Constitution, we make the following orders.
Yeah.
A. That the Electoral Commission take steps immediately to delete, or as it is popularly known, clean, quote unquote, the current register of voters to comply with the provisions of the 1992 Constitution and applicable laws of Ghana. And finally, B. That any person whose name is deleted from the register of voters by the Electoral Commission pursuant to the order above, that's order A above, be given the opportunity to register under the law. In effect, the tonic question is, does this mean that NHI card holders who use same to register and voted in 2012 elections must be deleted?
I would say to some extent, in that it means they have to appear before the Electoral Commission or its agents and be declared that they use the NHIS card and therefore their names are to be deleted.
Thank you. Hold on there for me. I've been holding Nana Asante-Bidietu on the line for quite a while. Thank you very much, Nana Asante-Bidietu, for joining us on the show.
Thank you. Thank you.
Nana Asante-Bidietu is a lawyer for Abu Ramadan and Evans Nemako. Nana, the cumulative effect, why are we having disagreements between yourself and the defendants on the question of deletion of ineligible persons, i.e. NHI card holders?
Well, thank you and good morning again to your listeners. Well, I'm not sure why the defendant, that is the Electoral Commission,
and the Attorney General.
And the Attorney General, yeah. I haven't heard from the Attorney General, but I suppose perhaps government spokesperson.
I've heard them. I've heard them. Their position and that of the EC is not different.
That is not surprising. But you see, I have to endorse about 99% of what I heard my brother Yao Opong put across on this issue. And I think if you look at what the plaintiffs went to court for, what the court has said, and the resulting orders, it is quite clear to me that the result is that those persons who have not established qualification to be registered must be deleted. Now, we, in our processes, in terms of the release we were seeking, didn't mention NHIS card. We mentioned those who have not established qualification to be registered. So what you just read on page 33 is in effect simply a reproduction of what we had asked the court, except that it does not include the portion that says that it should be, it renders the register unconstitutional.
Right.
Now, and so if flowing from that, it becomes very clear that if the court gives an order that there should be deletion, it can only be referring to those categories of persons, those who have not established qualification to be registered. And that includes people who use the NHIS card and persons who are deceased, and in terms of not establishing qualification, persons who are minors. So I don't think the order needs to spell out NHIS card holders or minors for it to make sense. It is very clear, and it flows from the judgment itself. So I don't think there should be any quibble about that.
You don't see there should be any quibble about that, but there is. And that is going to be another battle that you may have to fight. Now,
Yes.
Now, straightforward, tell me, the process requires, for example, that if you are going to enforce this, you have to file an entry of judgment. Is that not correct?
This is so, yes.
Okay. If you're filing an entry of judgment, you will limit yourself to the orders, correct?
Yes.
And the orders do not say specifically that NHI cardholders should be deleted. Don't you see there's a problem?
Well, I mean, we're looking at that because, to be honest with you, and I hesitate to say this, but frankly, I thought I had something slightly different in court. So I'm wondering whether on the order A, some words have dropped. And I've consulted other people who are in court who also appear to have heard what I've heard. But we know what to do about that. So we'll take the required steps. But I think, if you consider really what the court had said in the beginning, in the original case, and what the court is saying now, we really don't have a huge problem with the judgment. The wording of the order, as you say, may raise some issues. But I think that, for example, if everybody was working along the lines of wanting the best possible outcome, which is a good register and so on, really, we could even sit around the table and resolve these issues. But it seems to me that some people may have difficulties with such an approach, and it appears quite clearly that some people are resisting, doing what is right by removing these names. And so we are at this point. I don't know if you've seen the communication that the Electoral Commission has put out, which was, I think, signed by Mr. Amadou Sule, in which they talk about the processes that they had already began to implement in order to clean the register.
Right.
If you've seen it, you'll notice that they intend to use the exhibition period to so-called clean the register. That exhibition process includes the challenge process as well. So, for example, a third party, such as myself or you, Samson, would have to go to the center and identify someone who you think is not qualified, and then go through the challenge process, which would end up with a magistrate ordering that the name be deleted. There are several difficulties with that because it would mean I would have to know that Samson used an NHIS card or is otherwise not qualified. It's very difficult for third parties to know that. As you know, the CRAB committee itself suggested that kind of approach is too confrontational and unworkable. It's inefficient. The EC says that it will take biometric devices to these centers during exhibition so that if you want to go and confirm that you are in the register, you can do so. I think it is only one more step to do what the judgment, this judgment we're talking about says, and that is to make it mandatory that all of us should show up and all of us should go through the process of using the machines to verify our presence and then establish our eligibility to remain on the register. Because otherwise, the process that they've described, I'm afraid, will not end up removing ineligible people. Because if you don't show up, nothing happens. Your name still remains. So if you're an NHIS card holder, your name will still remain. If you use some other means to register, which is not lawful, your name remains. Nothing happens. So we must be very clear that process that has been outlined by the Commission, unfortunately, will not achieve the cleaning of the register unless it is made mandatory for all of us. And you see, one of the good things about doing it that way also is that it doesn't require the Commission to now trudge through all of the Form 1As that all of us filled out to register, to identify those who use the NHIS card so that they can then be deleted and then notified so they can re-register. Because all of us will have to show up. And because voting is voluntary and registration is voluntary, I can choose not to want to do that. I can choose not to want to show up. And if I don't show up because of I can't, maybe I'm ill or I've traveled, there's always an opportunity to register again because the CI 91 provides for continuous registration.
Okay.
And it can be a very, very simple process. But I'm afraid what they are saying they're going to do now will not clean the register. And I think we need to be very clear about that.
Okay. Now, I want you to you take leave of us after this very final questioning because there are 3 lawyers here in the studio. I'm sure that they'll be able to do justice to this matter. Now, my question to you is, the specific order is this, which the court said, this is the order. It says that the Electoral Commission should take steps immediately to delete, or as is popularly known, clean the current register of voters to comply with the provisions of the 1992 Constitution and applicable laws of Ghana. The Electoral Commission, it goes further, is supposed to do so using existing law, correct?
Well,
what I wanted to ask is there an existing law that provides how to remove the names of persons who registered with NHIS cards?
Well, no, there's not an existing law on that because it's as I've just explained, the existing law relates to the exhibition and challenge procedures,
right.
And I don't think that does the job. But you see, even the A, if you look at it carefully, it says that they should delete the register of voters to comply with the provisions of the 1992 Constitution. The 1992 Constitution under Article 42 says that only Ghanaians who are 18 years of age and of sound mind can be on the register. Ipso facto, if you are not a Ghanaian or you've not established that you are a Ghanaian, then you shouldn't be on the register.
Right.
This is an order of the Supreme Court. I don't know what other mechanism is needed to go, because remember also, Samson, that the court asked the EC whether they could identify the persons who used the NHIS card to register. And they answered in the affirmative, that if they go to the Form 1A, they can do so. So here's an order of the court saying that anybody, any voter or registered voter whose presence on the register does not comply with the provisions of the 1992 Constitution must be deleted. It seems to me that is an order of the court which can be complied with without using any other mechanism or subsidiary law, as you say. Okay.
You say that now that there's some disputes about what exactly the position is, you know what to do. What exactly are you going to do?
We will have to go back to the court.
Go back to the court to do what?
Well, you see, as I'm saying, I seem to remember I heard something quite different.
Okay.
You know? And that is why I don't know if words have dropped. We'll find that out. And if the court can always clarify an order.
Okay.
Yeah.
Right.
if required. So and remember also that whether there is existing law or not, the EC can in fact also promulgate a new instrument just on this to deal with what the court is saying if required. So if we want to do something, we can do something.
Okay. Thank you very much, Nana Santibidietu. Nana Santibidietu is lawyer for Abu Ramadan and Evans Nimako, who went to court and have subsequently been granted what we just have been talking about. Thank you very much. Now, let me hear Honorable Inusuf Hussaini. What's your understanding of the orders of the court?
Well, thank you so very much, Samson.
Specific to NHIS card.
Well,
Bearers.
I have a different view of the ruling of the Supreme Court. I think basically it appears to me that the ruling is so clear. It's so clear.
So clear to the effect that...
The effect that the law, the primary basic law says that every Ghanaian of sound mind ought to be registered.
Right.
The subsidiary law sets out the criteria for determining who a Ghanaian citizen is.
That's so.
And then proof of citizenship. Now, somehow, when the register was being compiled, some people used the NHIA cards as proof of citizenship to register. In an earlier decision of the court said those cards cannot otherwise be used to prove the citizenship of a Ghanaian to register to be on the register. That being so, those names or the names of people who use those cards to get onto the register ought to be deleted. Because that clearly doesn't establish them. I mean, it's not one of the criteria for establishing citizenship. Okay?
Right.
So they ought to be deleted. Simple. Secondly, the names of people who otherwise were qualified to be on the register but who have been deceased ought not to continue to be on the register. And so those names have to be deleted. Now, what the Electoral Commission ought to do is to set out an implementation strategy, because the court further said that those people cannot and should not be disenfranchised by reason of the fact that they use NHIA cards to get onto the register. That the Electoral Commission...
So you have an understanding that is different from what the AG seems to understand and what the Electoral Commission seems to understand. Your understanding is in accord with the understanding of the plaintiffs.
Yeah.
That those who use NHIS cards were not identified as citizens, and to that effect, their names ought to be deleted.
Simple.
But
That's what the
upon
court is
deleting,
saying.
they ought to be afforded the opportunity
to register.
To register.
Yes, that's what the court is saying. That's simple. That's how I understand it. It's clear. It's very clear. It's very clear to me.
In the earlier judgment that he's referring to, that almost all of us are referring to, in page 7, this is what the Chief Justice said. He said that, quote, since citizenship and nationality is critical per Article 42 of the Constitution, it is plaintiff's view that the health ID card is not an appropriate form of establishing constitutional qualification to be registered to vote, pursuant to Article 42 of the Constitution. The health ID card does not distinguish a Ghanaian from a non-Ghanaian when he or she proposes to have his or her name added to the voters' register. Indeed, the identification of a person in terms of Article 42 is not as important as the qualification of a person. While the health ID card identifies persons, it doesn't establish qualification in terms of Article 42. And in fact, she was quoting the plaintiffs in that regard before they emphatically endorsed that relief.
So Samson, I mean, all that we need to do as a country is to get the Electoral Commission to explain to us how they are going to proceed to implement the declarations of the court and what institutional mechanisms they are going to put in place to ensure that those who are otherwise entitled to have their names on the register, and that is those who are Ghanaians, but those who failed, refused, or neglected to establish their citizenship by the proper procedure, get their name back onto the register. That cleaning exercise will satisfy the plaintiffs who otherwise believe that some people who were otherwise not entitled to be on the register, but who used the NHIA cards, because those cards were also accepted and admitted for the purpose of establishing citizenship, will be removed.
By our understanding of the judgment, if NHI card holders are supposed to be removed, how is this supposed to be done?
Yes, so the Electoral Commission, they have the data. They compile the data.
They should simply go into their data and delete them.
They know the primary documents are available in their offices. They go back
from
to
1A.
From 1A, they go to back to the primary document, establish the names of those who use NHIA cards within the various jurisdictional or electoral areas, and display those names. There ought to be another display, another exhibition. Okay, so the people who have those cards can now then go cross-check to say, yes, my name is on the card, but I am a Ghanaian. I failed to use the proper procedure to register. I'm now entitled, because that is a fundamental right. Others who cannot establish that will have their names expunged.
Doc.
Well, something I am pleased a lot after listening to the submissions of Honorable Inusa, to the effect that the judgment is clear and that the Electoral Commission should do its work. But you know, a judgment on the face of it may be clear, but when it comes to the implementation, and the one who is supposed to engage in the act of implementing the judgment decides to play tricks, as it were, or decides to be intransigent, then it's going to render the judgment unclear. And that's exactly what the Electoral Commission is doing. You know, I have looked at its press release. If you look at bullet 3 of the press release, they are now shifting the obligation to comply with the judgment onto the ordinary Ghanaian. And that is inconsistent with the terms and tenor of the judgment. They are now saying that, if you look at how they've couched it, that, well, they are going to do an audit through the exhibition process. In doing so, if you have evidence of persons who have died, come and tell us, and we'll remove that person's name from it. In fact,
Bullet 3 says that the audit will involve removal of deceased registered voters, removal of multiple registrations with the help of the effects software, removal of alleged minors and non-Ghanaians based on the production of evidence.
that is the proviso I'm talking about. So they are now shifting that obligation onto the ordinary Ghanaian to present evidence of death of a family member. My grandmom died last year. I don't have her death certificate. The only evidence I may have with is obituary. You know, but here are documents which can easily be printed when the person may even be alive. So in trying to shift that obligation onto the ordinary Ghanaian as evidence based on which you can act to say that you're removing a person, is doing a serious disservice to the judgment, and is in violation of the judgment. That is why, if the Electoral Commission is not careful, it may be dragged to court again, and the more its name is taken through the judicial mud, it will lose its credibility. You know, if you speak of...
When you say it may be dragged to court again, you're talking about what Nana is referring to, as in go back to the court to seek clarity,
you know,
or what?
If you are serving the entry of judgment.
To cite it for commission of a high crime.
Exactly, for not complying with the judgment. Because when the judgment came out, then the pronouncement started from the deputy commissioner that already we are complying with the judgment by ruling out a procedure. But you know, before they went to court, they presented a case. What was the case they presented? The case they presented in court was that we have a procedure to clean the album. They did. And these were the procedures. But if those procedures and arguments you made to court have not been wholeheartedly accepted, it means that your procedure, which you presented before the ruling, is insufficient. So the judgment being clear means that we have Form 1A in your district offices. As to whether they are even intact is a different matter, but they have brought onto themselves a very serious challenge that you then have to go and produce all those forms because you told the court that you have them. So if you don't produce them to the satisfaction of the winning party, it means that they will not be pleased. They will then go back and say that you have failed to show them the form based on which you are going to rely and delete the names.
But you must also acknowledge the EC in its statement says, however, in the light of the recent Supreme Court ruling, the Commission is studying the judgment and its implications on the audit mechanisms outlined above, and the implications for registered voters who registered with National Health Insurance cards. The commission will make its views on the matter known in due course. So it does appear clearly from their statement that they don't think that what they have, the points they have stated here is the end.
But you know, then they should have waited to finish reading the judgment before releasing this statement. Because, you know, you allow a situation whereby propaganda will fester.
Yeah.
I mean, people have put a spin on this judgment, even though they are not lawyers, or even if they are lawyers, they are so biased politically that they don't want.
Expected.
No, but I mean, sometimes we come from a profession that will require you to live beyond certain level. I mean, as Honorable has done. That here is the case that the judgment is giving you powers to do an en bloc deletion. And then, by doing that deletion, you give an opportunity to persons who have been deleted to come and show proof of citizenship to take part in the process. So, you have the forms. You can then go to your database and do an en bloc deletion and then tell them these are the names who have been deleted from the register. If you exist, come and then show proof of citizenship beyond the NHIS card, and then you'll be allowed to register as a Ghanaian and take part in the process.
Okay.
I mean, just to make it clear, I mean, I've constantly heard this view. A court cannot give judgment. I mean, the laws have no retrospective effect, and the rest. It's a complete misnomer and misinterpretation of the law. I mean, let's look at Article 107 of the Constitution. Parliament shall have no power to pass any law, and in particular B, which operates retrospectively. I'm telling you, a court is not Parliament. You see, so the court will not give a judgment and go and annul an earlier elections and say that, well, because NHIS people took part in elections and therefore I'm annulling the elections. But a court can give a judgment that can have retrospective effect. So
because even when you read it in full, the qualifications are given
there.
To diminish
what Parliament can even do.
The accrued rights of a person, but it can enhance that right.
So at the time that Abu Ramadan had the first judgment in 2014, the Electoral Commission should have complied with that judgment, so that the effect is not carried into 2016 for you to get another Supreme Court judgment to say that, it's at the point, my hands are tied, so let me go and look for the forms. At that point, they should have done consistent deletion, and they would have been able to advance that argument that since that time, that judgment, these are the names you have deleted thus far because it's based on an NHIS card. And those people have the option to come and register. But they allowed the propaganda to be used, and then it actually prevented them from doing their work.
Okay, now let me hear from Kweku.
In ending,
you have
just a minute.
Right. Let him just finish and let me hear you.
Let me just end.
Yeah.
All in all, when we are done with this process, what are we going to have in hand? Is it electoral album that is reasonably credible? And that phrase has a meaning. It uses the ordinary person standard. The person who is in Medina Trotro, in Circle Trotro. That is why the word reasonable is there.
So ordinary.
So in the ordinary Ghanaian's perception, is it that we have been able to remove the names of dead persons? And the net effect of the judgment is that if we are not able to get these unqualified persons out of the album, organizing an election with that album in itself, voters register, can have two implications. The election itself will be in jeopardy of being stopped at the end of it all, when it was done in the case of the local government elections. Or even if the elections are conducted and there's sufficient evidence of non-compliance with that judgment, the election in itself could be annulled.
Okay. In fact, that's just riding on what he said finally. I think that the judgment places a greater responsibility on the Electoral Commission to do the proper thing. If they have not understood it that way, they better do. It means that you have on the register names of people who otherwise are not entitled to vote because of the qualification criteria. Their continuous presence on the register and their ability to vote in the election will consequently jeopardize the credibility of the elections and throw the whole exercise into jeopardy. And so for them, they need to understand that they take the judgment seriously.
Okay.
And work to remove
I'll return
these
to
things.
one other question which you are seeking to right now bring about, which is that if this is not done within the strictures that you understand, an election result is subject to further disputes in the court on the basis that this has not been followed. So somebody can go to the court and challenge the results on the basis that these names were not deleted pursuant to the order of the Supreme Court. Kweku, the judgments seem to summarize the purpose of the suit by the plaintiffs. When Justice Badewe says that the plaintiff's action seeks to give teeth and meaning to Articles 42 and 45A of the Constitution by ensuring that names of ineligible persons, minors, and descendants are deleted from the register before the upcoming public elections. It names minors, it names the dead people. Is it your understanding from the reading of the judgment through that the ineligible persons here refers largely or maybe just strict away to NHI card holders who were so declared in the earlier ruling, and therefore in the orders, when they use ineligible, they are referring to NHI card holders. So there's no need to even state NHI card holders.
Well, I think it's implied. If they didn't state it clearly, I think it's implied. Because if you read the judgment, they reinforced the earlier verdict they had made relative to the unconstitutionality of the cards being used as a basis for registration. It came up about 2 or 3 times in the thing, and that was key. Okay. So they really didn't have to mention it. And the EC statement, which I thought was significant, you know, the one you read, the portion that you quoted, shows that the EC itself admits that the cards, and I'm also choosing the short form that the Supreme Court used, is critical in the verdict.
Right.
The EC is not in self-denial relative to that point, and I think that's a very positive thing they've done. Did we have to reach this point? After listening to the real lawyers, true, authentic lawyers on this platform, I'm coming from my street corner, and I just asked myself, did we really have to get to this point? I think it was needless. We ought not to have gone the path of litigation to settle some of these issues. But clearly, there had been entrenched positions, and then also some political, you know, grandstanding relative to this matter, which we could have used consensus to push forward. So, well, eventually went to court, where if there is disagreement, issues are settled by law. And I think this is clearly what has happened. I realized that some people were looking at the reliefs in the original form and doing some mathematical calculations. You lost 3 here, I lost 1 here. And that actually clouded the essence of this judgment. That going forward, there had been a very significant point that the Supreme Court had made. And even some wanted to suggest that because they used the word clean, it meant that that's the same thing the EC is doing. The EC in that statement outlined the roadmap that he had come to in agreement with the parties on March 18th, 2016. In spite of the roadmap, and some are positive, some of the things there, they then come back to say that in view of the Supreme Court judgment, we need to study the thing and come out. So there's a new dynamic which has been introduced into this whole saga by the Supreme Court verdict. And to be honest with you, we just have to commit ourselves to it. But I realized that the Supreme Court also made a certain observation that in spite of the fact that we have a CI 91, which indeed cures the mischief, sought to cure the mischief of CI 72, there's still an inadequacy with CI 91 when it comes to the form of identification you used being captured on the database of the EC. Am I right?
Benny said that.
Yes,
Benny.
Justice Benny said, okay, that was a concurring thing, okay. So that's significant, that here we are now, we are challenged. I'm told the EC may have a huge problem actually identifying those who use the cards. That's what somebody tells me.
What
Even if
what
it's
is the understanding that makes it a difficult thing to do?
it appears it's a gargantuan exercise.
Because you have to go through every single
Yes,
Form A.
that we have to go through. And that's why if earlier there had been that consensus and commitment, perhaps time. But you see, the verdict is so clear that we can't use time constraint to avoid it. Meanwhile, we have an election to run.
In 5 months.
Yes, but it's 7 November 1, where we can still defer it. If time, if time is the matter, we can defer to December 7th. It's the handing over day that I'm sure you can't defer. You, the lawyers, can indicate
The election
that.
cannot go beyond December, after December 7th. It has to be before
that's
December 8th.
that one is cast in iron constitutionally.
Parliament will be dissolved on that date, and the Constitution is clear
so
about
we have that one is clear. But the 7th November is not cast in iron. If we're going to look at the time constraint as a factor, then we might as well take it back to the 7th, the usual December, and make sure we get this thing done. I'm happy the EC at least recognizes that a new dynamic has been introduced into the matter. They ought to sit down, study it, sit with all the stakeholders again, and move this process forward. All the other legal issues, I think the authentic lawyers have.
Kukuhakuko's authentic lawyers. So
They are genuine articles.
just hold on. We'll return to sort of fine tune and finish up on this matter, because it's very important, and many people who are watching and listening have questions that they have posed and they have sent them to us. So we're going to be dealing with them. Let's go for a quick break. We'll be right back.